Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London, and today I'm looking at a book which we reviewed before. It's now come out in a new edition. It's the 9th edition from LexisNexis. It's called Disciplinary and Regulatory Proceedings, and it's been written and edited by a number of people. The lead writers are Gregory, Treverton-Jones, Queen's Counsel, Alison, Queen's Counsel, and Saima, Hanif, together with members of 39 Essex chambers in London. Now, the book, as I say, has appeared for a number of years now, and it's an important book for lawyers and also anybody who is actually involved in regulation of one sort and another, whether being regulated themselves or actually acting as a regulator. It's a sign of the times that we have a very large amount of regulation, and of course the legal profession is one of the most heavily regulated professions in the Western world. Now, Elizabeth has been the lead writer on this review, and the title of our book review is The Law Relating to Professional Conduct, the definitive text, now in a new 9th edition, and the book appeared at the end of 2017. Let's have a look at the book first of all. There it is there. It's a hardback, and that's the spine. There's nothing on the back at all. It's quite a heavy book, as usual. It runs to something approaching 450 pages. The index, which is at the back, is by paragraph numbering, and you should be able to find what you're looking for quite quickly. It's quite a detailed index. It doesn't say it's by paragraph numbering, but it is, just so that you know. And you can see here for each chapter, the chapter heading has a number. This is chapter 17, and then it has the paragraphing after it, and you can see how it's structured. Lots of case law, of course, and you can see throughout quite a large amount of information, and there's minimal footnoting in various areas, but that's specifically to give things like case referencing. Now, if we go to the front of the book, and this is the first page here. Here we go. You can see it's under the LexisNexis publication logo, and it says that mentions the authors and all of 39 Essex chambers, so it's a chambers effort. Now, that's the basic blurb about the book itself, and then there's a preface written by the authors. There we go. That preface is dated October 2017, and it says the regulation of professionals continues to evolve at great speed. Absolutely. It's getting more and more complex, like everything else in society. It's a shame, but there we go, that's the way it is. Now, these are the contributors. I can't name them all, but you can see the names there. And you can see there's a group effort. Then the content section, split into various parts, and it names the people who've been involved in the specific chapters and the parts. As I say, there are 4 parts in total and 17 chapters. And as I've indicated, just repeat it, it's by paragraph numbering, so that is how you find the information. A lot of case law, and obviously there are other books in this area, but there's a lot of case law in this particular subject area. And then after the case law, you've got the table of statutes. Again, it's a range of different areas, obviously covering things like education, employment, financial services, and so forth. The Solicitors Act right at the end, and so on. Opticians. Then table of statutory instruments, again very important, secondary legislation, and then after that EU material. Now, whether we're obviously going to be leaving Europe, but we're still going to have European Union material with us for many years to come. Then you see the structure. Part 1, general, and then it kicks off. You've got the names of the people who've written it, the specific chapter, and then it kicks off immediately with the legal basis for the regulator's powers. And of course it all derives from Parliament and the politicians. Just opening it in the middle, disclosure and confidentiality, you see right in the middle of the book. And you can see the way the book is run. There's the paragraph numbering at the sides there, and occasionally there's a very small amount of footnoting. It's an important book, and it's one I think that everybody who's, as I said, involved in regulation should have certainly know about and should actually have a copy of in their firm or their chambers. Now, what do we say about the book? We say this: the law relating to the regulation of professionals forms the subject matter of this book, and it provides a detailed and carefully researched explanation of the regulatory framework which governs the conduct of professional activities. And it's now in its 9th edition, published by LexisNexis, and it is a distinguished work of reference which refers to what the editors call the myriad of rules and regulations which have evolved by political will in response to the perceived and obvious needs to maintain high standards among those delivering professional services. And to coin a phrase, they would say that, wouldn't they? Because whilst it's the political will in response to perceived and obvious need, there may be a need, but sometimes it goes too far. That can be a view of quite a lot of people who are critical of the amount, certainly, of secondary legislation. However, this book, I think, explains the problems that we've got within the regulatory process as well as it can be explained, because, as it said, it's a really complex area. Now, the result then is an ever-increasing body of case law and of decisions in this area as the jurisprudence which pertains to it continues to evolve. And that is the same with many other areas where we are getting much wider numbers of cases. And as we all know, the law reports have expanded from as 1 volume to 4 volumes. The whole area is becoming much, much more complicated as we move into the 21st century. And to deal with that, we need books of this nature. And it's particularly noteworthy with this book that is the range of professional services which it covers, and obviously related activities as well. And just about every category of human endeavour you might think of is either mentioned or examined in depth, from greyhound racing to, yes, legal services. And it's worth reading through the almost minutely detailed table of contents to get an idea of the scope of the book itself, which is divided logically over 17 chapters into the following 4 parts. Part 1 deals with the powers of regulators, the nature of professional misconduct, and the civil liability of regulatory bodies. Remember, if you are facing misconduct, it's the end of your life and your professional career if you lose, quite often. So the stakes really are very high, and regulation therefore should, as is the view of many people, be a relatively light touch. There's always a danger with certain types of government that it will become a heavy touch. And that has been an issue which has concerned quite a large number of people involved in this area for many years. Now, as I say, we're looking specifically at civil liability of regulatory bodies, where they can be called into account, of course, as well. And part 2 then goes on to cover the disciplinary process itself, from the investigation through to the hearing, and then the tribunal's decision and appeals and reviews. As I said, the stakes are very high. It's a person's life, not physically on the line, but his professional working life, his ability to earn money, and all of the problems that go with that. So the stakes are high. Part 3 then goes on to examine specific regulatory regimes, including financial services, legal services, healthcare, and numerous other professions, from accountants and architects to such bodies as the Rugby Football Union. Remember, there are a larger number now of bodies that need to be regulated, and Part 4 covers data protection and the freedom of information. And as we said, jurisprudential issues ranging from personal morality to public policy continually emerge throughout the book, making this a title all the more interesting because there's basically the human element involved. So it's an interesting read from a much wider perspective, not just the regulatory area. Now, for barristers and solicitors, the sections on financial services and legal services will prove the most interesting, we think, of the lot. Notable decisions on financial services, say the editors, are given special consideration, and also discussed is the conflicting case law in the sphere of solicitor regulation, which continues to be a problem. And of course the difficulty which we do have, which nothing has been done about, not likely to be done about, is the huge number of different bodies involved in regulating organisations like legal services. when you've got such a large number of bodies, they're all tripping over each other. And I have to question, as many people have done, whether in fact there's a need to have such a large number of bodies all busy running around spending our money as professionals, paying our dues, whether in fact that's absolutely necessary. The answer is it isn't, but of course it's giving people jobs. That may be controversial to some, but the problem is that you've then got a large number of different organisations that you're trying to deal with, and sometimes it's very difficult to know who you're dealing with, what type of systems and procedures they have, and so forth. That's why this book gives, I think, a wealth of very useful detail. And a whiff of conflict also emerges under the category of reserved legal activities defined under the system of regulation created by the Legal Services Act 2007 under the Blair government. Curiously, any activities not thus defined are not subject to regulation, the result of which is that it is open to any member of the public to provide legal advice for reward, i.e. McKenzie Friends, or for paid McKenzie Friends, for instance, provided, of course, that the person providing such advice, in quotes, such as it is not passing himself or herself off as a qualified lawyer. And as you are probably aware, if you put yourself forward, for instance, as a barrister at law when you're not, it's a criminal offence. Now, having said that, the issue of McKenzie Friends paid has never been dealt with. The issue of people in court who put themselves forward as legal executives or people who have a qualification when they don't is rife in many areas. It's a problem that hasn't been dealt with, because the regulators are dealing with one aspect and they're not looking at the much broader problems which are causing mayhem, frankly, because the quality of advice given quite often by these people who are not qualified is appalling. And nothing has been done, and nothing is likely to be done about it, because every politician has shied away, and Parliament therefore hasn't got a grip. It will do one day, but it's a long way off. Now, to say that all this is a source of resentment, and a sore point indeed, with hordes of qualified barristers and solicitors, is probably an understatement, bearing in mind that most of them, like me, we've all paid a great deal of money and spent a huge amount of time studying to qualify, and these people haven't. So you see why there is a little bit of a problem. Now, one can only suggest then that the public interest would be better served if there was a change in the law in matters such as this, because it's not just about the legal profession. There are quite a large number of areas where people are putting themselves forwards as consultants or whatever it might be, and they haven't got the qualifications. And there is a need for expertise. Whether some politicians accept that or not is a minor point. The fact is, if you are giving advice, you've got to be properly qualified. But as the editors remind us, of course, in the preface, limited progress has been made despite government commitments in simplifying the current regulatory framework, which they describe as often Byzantine. And just as a passing point, I wonder what Margaret Thatcher in 2018 would be thinking of this, because her whole purpose in the 1980s was to try to cut through some of the excessive regulation. And that was the case with people like Michael Heseltine as well. And I refer to that specifically because those were aims going back now 30 odd years, and we still end up with a very heavily regulated framework. And I don't see any real changes, and that's really one of the reasons why this book, I think, is so helpful. Let me conclude by saying that, considering the sheer complexity of the regulations governing the conduct of professionals, it's fortunate that this long-established legal text is designed for ease of use, and it is easy to use. It's not surprising that it's become known as one of the most useful tools available to practitioners and even non-practitioners dealing with disciplinary and regulatory proceedings. They're going to grow, there are going to be more and more cases, and there are going to be problems because some of the proceedings are clearly proceedings that shouldn't happen. But that is a matter for each of the individual areas of activity. But as I've said before, the likelihood of a major change is a long way off. So this book is absolutely fundamental if you're involved in any of these areas. And the editors and the contributors have endeavoured to state the law as it is at the 31st of August 2017, and I'm recording this at the beginning of 2018. The book's just come out. Here it is again. There's the front. Just opening it in the middle. Adjournments. This is pre-trial issues, so we're looking here at case management, pre-trial hearings, and everything else. And of course, you are getting to a point. This is about the General Medical Council. In fact, you are getting to a point with these types of hearing. This is the pre-trial issues in Chapter 7. You are getting to a point where it's just like the criminal system has exemplified in Archbold, which is getting bigger and bigger and bigger as time goes by. There will, I suspect, and it's going to be a matter of practicality, there will be a day that comes, as it did with the civil procedure rules when they were introduced by Lord Wolfe, where you have to call a halt to what has been happening and you have to have a complete reassessment. And I think at some stage, probably in the 2030s, that's probably when it will start looking at, people will start looking at it again. But at the moment, we are getting to a point where the whole thing has grown and grown and grown, and I don't see any likelihood of it stopping. It's the same with case law, and it's the same with Acts of Parliament, although Brexit, God bless its little cotton socks, has brought about a restriction on virtually every other aspect of legislation, because Parliament is completely fixed with dealing with that particular decision by the public to leave the European Union. And I believe the whole of 2018, most of our activities will centre around that. In the meantime, we have this excellent work from these very, very knowledgeable people, and I'm very grateful that they have come together to give us the new edition. Thank you to all of you very much indeed, because you make our lives a lot easier, because at least we can try to understand how the system operates. Thank you. Bye-bye.